Hello and welcome to the Analyst dated 12th August 2023 by Vajiram Ravi, wherein we will be covering the important current affairs articles from both the Hindu as well as Indian Express. And the handout of this very discussion would be available to you in the description below. Let's have a look over the articles that we are going to cover today. So firstly, we are going to cover the proposed changes in the criminal laws in India. Then we will be covering this aspect of multilateral development banks. Then we'll be looking into this issue of Adjournment Sine-Die, and we would also be, understanding the different terms which are related to the termination of parliament. Then we'll be looking into midday meal scheme. We'll try to understand the objectives, the basic features of this very scheme and how it is being implemented and funded. And lastly, we'll be looking into this issue of transfer of High Court judges. Now, this first article relates to the proposed changes in criminal laws in India. And this article pertains to this very aspect of your GS paper 2 syllabus. Let's try and understand the context first. So, the context is, recently the central government has introduced 3 bills in the Lok Sabha that proposes to completely overhaul our criminal justice system. Now, the first thing that we need to understand in this regard is, what are these 3 bills? These 3 bills are going to basically change the Indian Penal Code of 1860, then the Criminal Procedure Code of 1898, it was originally enacted in this year, and then it is going to change the Indian Evidence Act of 1872. Now those 3 bills are, when it comes to changing or replacing this IPC, that is Bharatiya Nyaya Sanhita. When it comes to changing this Criminal Procedure Code, it is Bharatiya Nagrik Suraksha Sanhita. And when it comes to Indian Evidence Act, it is Bharatiya Saksh Bill. Let's move ahead. Now, the first thing that we need to understand is, what is the need of these changes? First and foremost is the colonial legacy. Now, as you can very well understand by the dates on which these codes came into effect, is that these codes were basically drafted during the colonial times. So they basically reflect the social context at that time. So these codes and these acts are not able to reflect the current social dynamics which is in place. For example, we do not have any provision to address the issue of mob lynching. Then we do not have any provision wherein we can punish a person who is entering into sexual intercourse with a woman with a deceitful promise that he is going to marry that particular girl. So, in this background, we needed reforms in these particular laws in order to effectively reflect the current social dynamics which is there. Then, when it comes to the advances in technology, you would be astonished to know that the Indian Evidence Act was basically enacted at that time when we do not have the modern forensic technology. Now, in this background, we need to incorporate these modern forensic technologies when it comes to, investigating a particular crime, when it comes to gathering the evidences with regard to a particular crimes, which is basically absent in the Indian Evidence Act. Then, in order to simplify and streamline the criminal, investigation and evidence gathering process, and when it comes to the trial process, we needed changes in these criminal laws. For example, previously it was not allowed to carry on trial on video conferencing. It was not allowed to go for electronic filing of FIRs. And previously, it was not allowed to carry on the trial even when the accused person is absent from the court. So, in this background, in order to simplify and streamline the procedure, we needed these changes. Then in this regard, various committees like Malimath Committee, Besbura Committee, Vishwanathan Committee and the departmental related standing committees on home affairs in its 146th report and in its 111 and 128th report has pointed out that there is a need for reform in these criminal laws. So in this background, the government has proposed these changes. Now, let's look into the proposed changes in the IPC, Indian Penal Code. First is, we have expanded the scope of offences when it comes to women in India. Now, if a person enters into sexual intercourse with a woman with a deceitful promise that I will marry you in the future date, then it could be considered as an offense. Now, then we have a separate provision to address this menace of mob lynching. Now, if a mob of 5 or more people commit murder on grounds like race, caste, community or personal belief, then such people would be awarded with imprisonment up to 7 years or life imprisonment or death penalty also. Then government has proposed to do away with the sedition provision that was earlier provided under section 124A of IPC. And now we have defined this term effectively under section 150 of the new bill. What all changes we have witnessed when it comes to defining this word sedition under section 150? Now it states that if a person purposefully or knowingly does any act which is considered to be as offense against the state, and if that activity endangers the sovereignty, unity and integrity of India, and if such a person, by word, either orally or by written, by signs or by verbal representation, in electronic communication or through financial means, these two things have been added. If by making use of these means, if a person commits any activity which is considered to endanger the sovereignty, unity and integrity of India, then that person would be punished with life imprisonment, or that person would be punished with 7-year imprisonment plus fine. Okay. Then we have introduced new forms of punishment like community services, which was not previously available. Then it provides for summary trials for petty offences like thefts. What are summary trials? Which are concluded very speedily. So for petty offences like theft, like trespass, etc., it provides for summary trials, that is speedy trials with regard to petty offences. Now let's look into the proposed changes when it comes to the Indian Evidence Act. It provides for mandatory use of forensic technology in all the states and union territory. And it also provides that there needs to be forensic experts with regard to dealing with such offences wherein that offence is punishable for 7 years or more. Then, in order to make sure that the police in every state and UT is able to make use of this modern forensic technologies, necessary infrastructure would be put in place within a time frame of 5 years. Then it also states that now the electronic or digital records would also be considered as legal documentary evidences. And it also provides that what would be the secondary evidences. Secondary evidences are if you have produced a copy of the original documentary evidence, or a person who has seen that original documentary evidence, and if that person is orally providing you that what was there in that original documentary evidence, then such things would be considered as secondary evidences. Let's have a look over the proposed changes in the Code of Criminal Procedure. First and foremost, it provides for greater use of technology, that is trial through video conferencing. And it also provides that whatever investigation, whatever evidence you are gathering, you need to record it in electronic medium. The statements of the accused, and if a person is, let's say, arrested, the name of that person, what offense for which that person is arrested, that all data needs to be recorded in electronic medium. So it provides for greater use of technology. Then, as I have told you, in order to streamline and simplify the trial procedure, what the government has provided is trial in absentia of the accused person. Okay, in order to provide a closure to the victim. This basically implies that the accused person has given its right of fair trial. What is right of fair trial? When the accused person, defends himself with the help of a legal practitioner and he or she is present in the court. But according to the proposed changes, what we have provided is, even if the accused person is not present, then also the trial can continue in order to provide a closure to the victim. And this trial could be started after 90 days after the charges have been framed against that accused person. This was not previously the case. Previously, if the accused person is missing, then the state authorities were, it was a duty of the state authorities that they have to locate that person, and then only the trial could begin. Then communication devices. Now, on the direction of courts or on the direction of police officer, now a person has to produce the documentary evidences as well as electronic devices which might be containing the digital evidence with regard to a particular offense. Now these digital evidence could be in form of written evidence, it could be in form of pictures, it could be in form of videos, etc. Then it provides for specific safeguards as well. What are the specific safeguards? Now no person can be arrested without getting a prior permission from an officer who is not below the rank of Deputy Superintendent of Police. If that person has committed an offense which is punishable with imprisonment up to 3 years, or if that person is above 60 years of age. But when it comes to the offenses which are punishable with 3 to 7 years of imprisonment, then the police officer has to conduct the preliminary inquiry in order to make sure that whether to continue with that case or not. And this preliminary inquiry needs to be done within 14 days. Then, when it comes to the mercy petition, what all changes it has proposed? It has stated that once the court has awarded death penalty to a person, then that person or his or her relative can appeal before the governor. They can file a mercy petition before the governor within 30 days. Okay? And if this mercy petition has been rejected by the governor, then within a time frame of 60 days, they can file a mercy petition before the president. And if the president also rejects this mercy petition, then no appeal can be filed in any court against this presidential order in this regard. Then, when it comes to, prosecuting a public servant, what the Code on Criminal Procedure, the changes that it has been, stated is, the government needs to provide the sanction in this regard. Okay, the government either needs to grant the sanction or reject the sanction when it comes to prosecuting a public servant. And whether to reject or to grant the sanction when it comes to prosecuting a public servant, this decision the government has to take within a time frame of 120 days. Let's suppose the government does not take any action, okay, then it would be considered that the government has given the permission to prosecute a public servant. But this prior permission would not be required to prosecute a public servant if that public servant has committed crimes like sexual offenses or trafficking, etc. And lastly, the magistrate can order a person to provide samples. What are samples? Like your signatures, like your voice, like your thumb impression, finger impression, etc. Even, in the case that that person has not been arrested. This is being done in order to aid the investigation process. These all changes have been proposed in these criminal laws. Now, these proposed changes have been referred to the parliamentary standing committees. After the parliamentary standing committee would go through these particular changes, it would revert back the bills to the House. Okay, let's see what happens after that. Maybe these bills would again be reintroduced in the next session of the parliament. That is all that we need to know with regard to this article. Let's move to the next one. Now, this next article basically pertains to multilateral development banks, and this article pertains to this very aspect of your GS paper 3 syllabus and this aspect of your GS paper 2 syllabus. Let's try and understand the context first. So the context is, recently the Union Finance Minister of India has stated that the primary focus of India's G20 presidency in 2023 has been to strengthen the multilateral development banks. Now in this regard, the first thing that we need to understand is, what are multilateral development banks? So multilateral development banks are basically the financial institutions which are created by a group of countries whose main objective is to basically provide the loans, the technical support to developing and least developing countries. Examples are World Bank, Asian Development Bank, IMF, etc. Now the thing that we need to understand is, what is the relevance of these banks? First and foremost, they provide financial assistance to developing as well as least developed countries. When it comes to, developing infrastructure projects, what is being done by the World Bank, one of its arm, International Bank for Reconstruction and Development. It is providing loans to the developing countries when it comes to developmental projects. And they also provide financial assistance to such countries when it comes to carrying out projects which intends to reduce poverty in these countries, which is being done by one of the arm of World Bank, that is International Development Association. Then they also possess development expertise. Take the example of India. We were able to implement LPG reforms with the help of IMF, and this considerably helped the Indian economy to grow in the recent times on account of LPG reforms. Then it also enables the developing countries to promote SDGs. For example, they provide the finance to such countries when it comes to building adaptation and mitigation projects. Okay. In this regard, the Asian Development Bank and the African Development Bank are doing very great job when it comes to providing climate finance. Okay. Then they are also playing a major role when it comes to addressing the global challenges. For example, after the pandemic, World Bank came up with a fund for prevention, preparedness and response when it comes to the pandemic. So they are playing a major role when it comes to addressing the global challenges, like financing the developing and developed countries when it comes to the pandemic related issues, when it comes to the climate related projects which are there, etc. So these are majorly the relevance of these particular banks. Now the next thing that we need to ponder over is, why these banks need reforms? The first reason is the issue with their governance structure. In majority of the multilateral development banks, what we are seeing is there is hegemony of developed countries. For example, in World Bank, there is hegemony of USA. When it comes to IMF, there is hegemony of European Union. When it comes to Asian Development Bank, there is hegemony of Japan. So what is happening on account of this is, these multilateral development banks are not able to address the issues which are being faced by the developing nations, because the developing nation or the global south basically does not have adequate voice when it comes to sanctioning of projects when it comes to multilateral development banks. So these banks are not able to reflect or to address the aspirations of the developing or the nations which are there in the global south. Then it is not able to reflect the contemporary realities. These banks are not able to address the challenges which are being faced by developing countries, like developing adaptation and mitigation projects. Then enabling these developing countries when it comes to disaster risk reduction, pandemic related issues, when it comes to developing global public goods. So these multilateral development banks are not able to address the aspirations of the developing and least developed economies which are there. Why this is so? On account of procedural delays. As I told you that there is hegemony of the developed countries in these banks. So at times when it comes to financing the projects in developing or least developed economies, we witness procedural delays when it comes to these banks. And lastly, they lack transparency. Although, as we studied right now, that the African Development Bank and Asian Development Bank are doing very great when it comes to providing climate finance. But there is lack of transparency. We do not have any set of data when it comes to the projects which are being financed by these multilateral development banks. So we do not have project level data. And when you do not have this data, what is the issue? The developing economies are not able to hold these banks accountable. And if there is no data with regard to the projects which are being financed by these banks, it is bound that some of the money would be used for corruption purposes. And it would not be able to serve the purpose for which it is being dispersed by these banks. Now, the last thing that we need to note is what all reforms are needed when it comes to these multilateral development banks. It needs to adapt to the evolving global challenges. It needs to provide voice to the global south. It needs to come up with flexible, financing models which are able to address the emerging and the evolving global challenges. Like climate issues are there, like developing the disaster risk ability of the developing countries, building global public goods, etc. Then it needs to enhance its funding mechanism. What is happening is the developed countries are basically demanding more concessional loans from these banks, but they are not able to get adequate private finance in this regard. So in this regard, what reforms are needed so that it has the requisite finance to finance the developmental and climate related projects in the developing and least developed economies. It needs to enhance the contribution of the member countries, and it also needs to attract the private investment. Then when it comes to governance and representation, the governance of these banks need to undergo a change. The hegemony that we are seeing when it comes to these multilateral development banks, that needs to change. The hegemony of developed countries when it comes to these banks need to change. These banks need to provide adequate voice and voting share to the countries which belong to the global south, basically the developing countries. Okay? So that these banks are able to clearly reflect the change in balance of power that we are witnessing now. Then it need to make use of the technologies like artificial intelligence, like data analytics, like blockchain technology in order to enhance transparency when it comes to the finance which is being given by these banks to finance the different projects, developmental projects, poverty reduction related projects, climate related projects in developing and least developed economies. So when these technologies would be used, it would become easier for the developing and the least developed economies to basically hold these multilateral development banks accountable. Okay? So these are things we need to note down with regard to this topic. Let's move to the next one. Now this next topic basically relates to the terms which we are going to study when it comes to the termination of parliament. This topic relates to this very aspect of your GS paper 2 syllabus. Let's try and understand the context. So the context is, yesterday only both the Lok Sabha and the Rajya Sabha were adjourned sine-die. Now what is exactly in news? On account of opposition from the opposition political parties, we witness a lot of disruptions in both the house. And in this regard, the Speaker of the Lok Sabha has pointed out that the Lok Sabha was able to attain only 45% of its productivity. And when it comes to Rajya Sabha, on account of the disruptions which it witnessed, it lost around 50 hours of its time. So in this regard, what we are going to study is the terms which are related to the termination of the parliament. The first term is adjournment. Now, this power is basically given to the presiding officer of the house. Okay, that means the speaker in the Lok Sabha and the chairman in the Rajya Sabha has this power to adjourn the sitting of the house. So it basically terminates the sitting of the house for a specified time frame. So whenever the presiding officer adjourns the house, then he would be providing the date or on the time on which the house is going to reassemble again. Then we have adjournment sine-die. This also terminates the sitting of the house. And again, this is done by the presiding officer of the respective houses. But in this case, what is the difference is, the presiding officer would not tell that on which date the house is going to again reassemble. Okay, so the house is not adjourned for a specified time. Although it is up to the presiding officer, he can call the house that we again need to reassemble before the specified time when it comes to adjournment. So this is the basic difference that you need to make note of when it comes to adjournment and adjournment sine-die. Both are done by the presiding officer, both terminates the sitting of the house, but in adjournment, the presiding officer would be providing a specified time frame within which the house would again be reassembling, but that is not the case with adjournment sine-die. Then, after the presiding officer has declared adjournment sine-die, when the house has completely transacted its business for that particular session, then within a few days, the president issues an order with regard to prorogation of the house. So prorogation basically terminates the sitting as well as the session of the house. So now, as the presiding officer of the two houses have declared adjournment sine-die, within a few days, the president would be notifying an order with regard to prorogation of the two houses, which would basically be terminating the monsoon session of the two houses. Then we have the last term, that is dissolution. Now this dissolution basically ends the very life of the Lok Sabha. We know that Rajya Sabha is not subjected to dissolution according to Article 83 subclause 1. Okay, because it is a continuing chamber, and when it comes to Rajya Sabha, every second year 1/3 of its member retire. So there is no dissolution when it comes to Rajya Sabha, whereas it is the Lok Sabha which undergoes dissolution under Article 83 subclause 2 and under Article 85 subclause 2 subclause B. So dissolution basically ends the very life of Lok Sabha. So after dissolution, fresh election needs to be conducted. Okay, so a new Lok Sabha would be constituted after dissolution. Now, the thing that we need to understand before we move on to the next aspect is, why would the president dissolve the Lok Sabha even before expiry of its term of 5 years? Because the president can do so even before the current Lok Sabha has completed its term of 5 years. But in this regard, the president can take action only on the aid and advice of the Council of Ministers headed by the Prime Minister. Now the question arises, why would the Prime Minister advise the President to dissolve the Lok Sabha even before expiry of its term of 5 years? This could be on account of two reasons. First is, the government of the day basically prefers to dissolve the Lok Sabha at a politically opportune time. Okay, for example, let's suppose, I'm just taking a hypothetical example. Let's suppose the current Lok Sabha is supposed to be dissolved in December this year. But let's suppose in this month only, a particular issue is going on which the government of the day feels that if we dissolve the Lok Sabha right now and if we conduct fresh elections now, we would be getting majority of the voting share. Okay, so we would be able to come up with a huge majority in the next Lok Sabha. So this is one reason on account of which the Prime Minister advises the President to dissolve the Lok Sabha, to basically make use of politically opportune time. Then is to resolve the deadlock between the executive and the legislature. This basically we witness when there is a coalition government. Although on account of support by different political parties, a coalition government is formed, but we know that political parties differ when it comes to their political ideologies. So on account of this, what happens is the executive is not able to get the major bills get passed by the House. So in order to resolve this executive and legislative deadlock, at times the government, the coalition government, which is headed by the prime minister, the prime minister of that coalition government would be advising the president that you please dissolve the Lok Sabha, so that maybe in the next Lok Sabha we would be able to come up with a huge majority. So these are basically the two reasons on account of which the executive or the Council of Ministers headed by the Prime Minister would be advising the President to dissolve the Lok Sabha. Now the next aspect that we need to understand is, what is the difference between adjournment and prorogation? When it comes to adjournment, it basically impacts the sitting of the House. So it basically terminates the sitting of the House, but when it comes to prorogation, as I have told you, it terminates both the sitting as well as the session of the House. When it comes to adjournment, it is being done by the presiding officer of the House, but when it comes to prorogation, it is done by the President of India. Then, when it comes to the impact of adjournment on the pending business of the House, or when it comes to the bills which are being introduced in the House, there is no impact, okay, on account of adjournment of the House. But when it comes to prorogation, it also does not affect the bills which are being introduced in the House, but it does have an impact on pending notices. So it does away with the pending notices which do not deal with introduction of bills. Okay, so apart from the notices, pending notices which do not deal with introduction of a particular bill, all the other pending notices would be done away with. However, in case of Britain, on account of prorogation, all the bill and the pending business are done away with. Then last thing that we need to understand is, what is the effect of dissolution on the parliamentary business. So on account of dissolution, 4 types of bill would not get affected, okay, they would not be getting lapsed. One is, if a bill is pending in the Rajya Sabha and that bill was not passed by the Lok Sabha. Secondly, if there was a deadlock between the Rajya Sabha and the Lok Sabha, and before the dissolution of the Lok Sabha, the President has notified the organization of a joint sitting, then in this case also that bill would not get lapsed. Then if a bill has been passed by both the houses but it is pending the presidential assent, then also the bill would not get lapsed. And lastly, if a bill was passed by both the houses, it went to the president, but the president has again returned that bill for the reconsideration of the parliament, then also that bill would not get lapsed. And the assurances which are pending before the Committee on Government Assurances, that would also not get lapsed. Okay, the assurances which this Committee on Government Assurance has to examine. Then what all bills would get lapsed? Which are pending in the Lok Sabha. Either they originated in Lok Sabha or they were transmitted to the Lok Sabha from Rajya Sabha. They would get lapsed. Okay, so these kinds of bill would basically get lapsed. But the other 4 kinds of bills that we discussed, they would not get lapsed. This is all that we need to know with regard to this article. Let's move to the next one. Now this next article relates to midday meal scheme, and this topic relates to this very aspect of your GS paper 2 syllabus. Let's try and understand the context. So the context is, recently 28 students of MCD school in West Delhi fall ill after eating midday meal in their school. Now the thing that we need to understand firstly is, what is this midday meal scheme all about? The scheme was initially launched in 1995, but at that time its name was not midday meal, but rather its name was National Program for Nutritional Support to Primary Education. Its name was changed to midday meal in 2007. So under the scheme, basically fresh cooked meal is being provided to the students who are studying in class 1 to class 8th. Okay, in all the government school, government aided school, madrasa, maktabs, which are basically under the Sarva Shiksha Abhiyan. The thing that we need to understand with regard to midday meal scheme is, what is the objective of this very scheme? The objective is to increase the enrollment ratio, basically with regard to the students who belong to disadvantaged section of our society. Then to improve the attendance of such students who basically belong to disadvantaged section of our Indian society, and to address the issue of hunger and malnutrition, especially with regard to the students who belong to vulnerable sections of Indian society. These are the broad objectives of midday meal scheme. Then what are the features of this very scheme? The features are, under this midday meal scheme, egg mark quality products are being procured under the midday meal scheme. What is this egg mark? This is basically a quality assurance with regard to agriculture products, which basically states that this agriculture product meets the standard which has been set by Ministry of Agriculture. Then under this midday meal scheme, there is a school management committee. So out of the school management committee, 2 or 3 adults would be tasting the fresh cooked meal which is being prepared under the midday meal scheme. Then the Food and Drug Administration Department of any state can get the samples of the quality of food which is being provided under this midday meal scheme to basically test the quality and the nutritional value of the food which is being served to the children under this midday meal scheme. And when it comes to the implementation of the scheme, for implementation of the scheme, the state has to, create a steering and monitoring committee at the state level, at the district level, and at the block level to basically ensure the implementation as well as effective monitoring of midday meal scheme. And if on account of unforeseen circumstances, the government is not able to provide fresh cooked meal to students under this midday meal scheme, then they would be provided with food allowances. When it comes to the funding, it is a centrally sponsored scheme. So the cost of the scheme is basically shared between the center and the state in a ratio of 60 to 40. 60 is borne by the center government and 40 is beared by the states. And the nodal ministry of the scheme is Ministry of Education. This is all that you need to know with regard to this particular article. Let's move to the last article. Now, this last article basically pertains to the issue of transfer of High Court judges, and this article basically relates to this very aspect of your GS paper 2 syllabus. Let's try and understand the context. So the context is, recently the Supreme Court Collegium has recommended transfer of 24 judges from High Court across the country. Even when these judges were basically making an appeal before the Supreme Court that you please reconsider the transfer orders. Now, the first thing that we need to understand in this regard is how the High Court judges are appointed. So, the High Court judges are appointed under Article 217, Subclause 1 of the Indian Constitution. They are appointed by the President after consulting the Chief Justice of India. When it comes to the appointment of Chief Justice of High Court, in this regard, the President has to consult Chief Justice of India plus the Governor of the concerned state. Okay, but when it comes to appointment of other High Court judges, in that regard, the President has to consult the Chief Justice of India plus the Governor of that state plus the Chief Justice of the concerned High Court. In this regard, in the third judge's case, that is in Presidential Reference 1998 judgment, the Supreme Court stated that when it comes to appointment of High Court judges, the CJI needs to consult 2 senior most judges of the Supreme Court in this regard. Okay, so this is regarding the appointment procedure of High Court judges. Let's look into the aspect of transfer of High Court judges. Now, this transfer of High Court judges is basically done under Article 222, Subclause 1 of the Indian Constitution. In this regard, it is the President only who is going to allow for transfer of a High Court judge, and in this regard, the President has to consult the Chief Justice of India. Now, in this regard, we have certain prominent judgments of the Supreme Court. For example, in India versus Sankal Chand Himmatlal Seth 1977 case, the Supreme Court stated that when it comes to the transfer of High Court judges, it should be done in public interest and it should not be used as a way of punishing that High Court judge. Then, in Supreme Court Advocates on Record Association versus Union of India case 1994, that is popularly referred as the second judge's case, the Supreme Court stated that When it comes to the transfer of High Court judges, it would be subjected to judicial review to basically put a check on the arbitrariness when it comes to the transfer of High Court judges. And in this regard, the judge, the High Court judge who is being transferred, only that judge has the right to go and file an appeal in the court with regard to the transfer orders. And lastly, in the third judge's case, which is famously known as in re presidential reference 1998 judgment, the Supreme Court stated that when it comes to CJI, the CJI has to give recommendation when it comes to transfer of High Court judges to the President after consulting 4 senior most judges of the Supreme Court and after consulting the Chief Justice of the 2 concerned High Court. What are the 2 concerned High Courts? High Court A, High Court B. High Court A, from where the High Court judge is being transferred to High Court B. So the Chief Justice of both these High Courts need to be consulted. So when it comes to recommending the President with regard to transfer of High Court judges, the CJI needs to consult 4 senior most judges of the Supreme Court and the Chief Justice of the 2 concerned High Courts. That is all that we need to know from today's newspaper. Thank you for listening to this very discussion and all the very best for your preparation.